if you want to, try and save on legal costs a little bit and put something together with your AI and then have an attorney review it and beef it up and, close a lot of the gaps, then, that's one thing. But I strongly recommend people don't just take it and then start using it. You have this great idea, you're starting your own business. I would certainly, like we discussed earlier, form some sort of entity to get you liability protection.
Hello, everyone. Welcome to another episode of Truckloads of Money. We have a very exciting guest today, business attorney Robert Castle. Rob has been working with our company, AST Safety Consulting, for our needs. And when working with them, it's been obviously not only very useful for our business needs, but also very educational. And I thought Rob would make a great guest because I've discovered a lot of things I didn't know about, um, you know, legal side of running a business. Hello, Rob, welcome.
Thank you so much for having me, Andre and Anna. I really appreciate it.
And yeah, let's just start with a little bit of your history. How did you get into law? What make you choose this particular area of the law? So just tell us a little bit about
Yeah.
yourself.
So I'm Rob Castle. I run the Castle Law Firm out in the Chicago suburbs. And I work with businesses of all shapes and sizes in structuring their operations, drafting and negotiating their contracts, and just helping them make smart business decisions while managing risk. And, I also work pretty heavily in franchising. So, if somebody wants to open up a Jimmy John's or a McDonald's, I help them, get started in that. And basically, I was drawn to this area of laws because, I think it was interesting. It's kind of a more proactive area of law as opposed to, certain other areas that are more reactive. So, not only do I get to help people achieve their goals of, owning their own business, but we also get to think, 2, 3, 4, 5 steps ahead of, okay, here are some of the challenges and landmines we might face, in our specific industry, and how do we draft contracts and kind of structure, the entity and the business in a way that can help us avoid some of those pitfalls. Whereas, other areas are more, reactive. People come and, hey, I was served with this lawsuit, or I'm in the middle of this, tough dispute. And how do we kind of react to it in that way? And I do get to face, some of those challenges as well. But most of the time it's, with proper planning, we're looking ahead and looking forward to try and avoid a lot of that, which is,
Right.
it's good.
Sounds a lot similar to what we do as a compliance company. Like that's what we focus a lot on, preventing problems down the road. Like, okay, let's take care of certain things that are important before something bad could happen, like
Yes,
a lawsuit.
absolutely.
And yeah, that speaking of which, speaking of different areas and types of lawyers, is that a misconception that you encounter every once in a while when people think of a attorney or a lawyer, they picturing a lawyer that goes to court and talks to
Yeah.
judges and things like that.
Yeah, sometimes people don't necessarily understand the difference, that there's different types, transactional compliance attorneys versus, litigators. But it's never really a problem. We, people call and we educate them on the difference and help them out to the extent that we can and kind of take it from there. But, I have dealt with, little flare-ups that have happened, disputes between partners and, business disputes and whatnot. But our goal is really to put out the fires before it blows up into something and big. And, luckily, we've been successful at doing that. So
What is the biggest legal mistake small businesses or businesses in general do when they're starting a business?
I would say not getting all of their ducks in a row from the get-go, from the beginning. My grandma used to say a stitch in time saves nine. So, I see people, when they're starting up a business, they just want to hit the ground running and start doing what they're doing, taking on clients, taking on customers. And that's great. I certainly understand that. But a small investment in, getting your entity structured properly, getting your internal ownership documents structured properly and having them be really clear, and also having your external customer facing documents, whether you're working with clients or suppliers and vendors, whatever the case might be, having those airtight is essential to really, getting off the ground with your business. And I see a lot of people who say, hey, I figure I'll go, invest in some legal when I actually need it. But the problem is you don't really need a lawyer until you actually need one, right? So, and then at that point, in order to fix any issues that you have going on, it's going to be a lot more expensive financially. It's going to be a lot more time consuming. And it's going to cause a lot more stress on you too, when you should be focused on growing and expanding your business. So I always tell people, if they either haven't started their business yet or they're in the very early stages, just to, invest a little bit now, time, energy, money, whatever the case might be, into legal compliance and just making sure that everything's structured appropriately, because it'll save you a lot of headaches down the line.
Mhm.
Mhm.
And so when when it comes to structuring a business, choosing the correct like legal entity, how is your work different from, say, a CPA's work, like, or a tax advisor? Like, who would be better, or like, what are some of the different things that you could help with versus people who dealing primarily with finances and tax?
Yeah, absolutely. So, I mean, I'm happy to, depending on your industry and business, I'm happy to work hand in hand with, tax professionals, and I have on occasion. But it really depends on the type of industry you're getting in, what your goals are, how large your business is going to be, etc. I would say for 9 out of 10 people that I work with, an LLC is a great option to start out with, because that offers the most flexibility for you in growing and expanding, and offers a great level of liability protection from a legal standpoint. People often come, like, and say, "Hey, well, how about partnerships?" I mean, a partnership is a lot less formal, does not offer the same level of protection. And then people also have questions, are, the big two are LLC versus a corporation. And a corporation, I say, I mean, that's a great option if if you're either very large to begin with, or you plan to grow, if you have 250, 500 employees and you plan to issue stock and you want to raise capital and all of that, then a corporation is likely, the way to go. But like I said, for 9 out of 10 people that are starting, a small or medium-sized business that want to scale this over time, I think an LLC is a great option. And as they grow, if you ever want to convert, that can obviously be done too. But as far as, me and the tax professional, they'll look at things kind of on the inside of, your financials and, what would be most beneficial between the LLC and the corporation option. But like I said, most people starting out, you don't even have to take that extra step, because if you're just, a smaller operation that wants to grow over time, an LLC would really be a way to go.
What about, say, like a side business, or a smaller business? Say you do have your main business, your small business owner or medium business owner, doing something like anything, but you also have a couple of rental properties that you rent out on Airbnb or long term,
Yeah.
and there are opinions. Okay, well, it's small enough that I can just do as a solo or myself, versus a lot of people saying, okay, there should be an LLC.
Yeah.
So what's your take on it?
Well, I would always recommend to have some sort of business structure or entity. For the main reason being is to protect yourself from liability. And, I've encountered this a lot, especially over the last few years. People are kind of starting side businesses and, little side hustles, as they call them. And especially as they grow, it's always good to have some sort of structure that'll enable you to get, separate business bank accounts, and that, liability protection that's so important. And it's just very important that when you do that, even if it's just a kind of a small little side business, to keep things clean and separate, right? So you don't want to commingle funds, or, take money out of your personal and, start moving it regularly into your business, or vice versa. You want to keep things very clean from an accounting standpoint. And, I work hand in hand, like I said, with tax professionals, accountants, whatever, to, help assist with this end. But, that's very, very important. And whatever you choose, make sure not to commingle funds. That's like a big one and a big
Uh,
red flag. So.
And
okay.
speaking of it, what is the worst that can happen? Let's say I have a small company, I only have one truck, and I work for myself. Like I have a small corporation, and like I don't have a small corporation. I'm sorry, I have everything under my name. So I bought a truck under my name. I have my like I'm getting all of the transactions under my name. Can IRS take all of my money if something will go wrong? Like,
So, one of the main concerns would be if you're working as a sole proprietor without any
mhm,
liability protection through an entity, would be that, if something were to go wrong, there was an accident or, compliance issue, whatever the case might be, and you end up getting sued, they can come after you personally. So,
Okay.
they would come after your personal bank accounts. Certain types of retirement accounts can be touched, certain can't. But
Mhm.
that's, where you'd work with an accountant, tax professional to, hopefully protect certain things. But it's a big risk. And I would never recommend anyone to do
Mhm.
that because you're really opening yourself up to a lot of liability. If you own real estate and you're not able to satisfy, any judgment against you, they can come after that. There's a whole slew of issues that can arise. So just taking again that small investment to form an LLC, or some sort of entity protection can shield you in most cases from any of that, assuming things are done right. That's why I mentioned, please do not commingle funds or do anything that way, because then that can open up the door to, hey, now we're going to come after you personally. But assuming that things are done properly, you keep things separate and everything is above board and clean, excuse me, you most times will be good.
Mhm. Okay, so
Mhm.
now it made me thinking about Airbnb business that I have.
Yes, I mean, yeah, you can form. There's something called series LLCs if you have several different properties.
Mhm.
But at a bare minimum, having some sort of entity and structure in place, I think, would be very beneficial for you.
A lot of trucking companies keep drivers on 1099 long
Hmm.
term instead of hiring them on 10 W-2 employees. And what are the differences between 1099 and W-2?
Yeah. So there's a number of classifications and kind of items you would want to hit in order to classify somebody between an employee and a independent contractor.
Mhm.
And it really comes down to the level of oversight that the company that they're working for, either as an employee or a 1099, has over the individual. And the tough thing about this is there's no black and white answer that I can give you to say, oh, well, 100% of the time this is going to be a W-2 classification versus a 1099 classification. I mean, it's really, a lot of it is kind of a gray area, but some of the elements that go into it are, if the employer, exerts, you know, a certain level of control over the, worker, um, that would generally trend to be deemed as an employee. If they mandate, the working hours, a lot of times, is one kind of factor involved in it. If they, mandate them to be at, on a certain site at a certain time, that's that. If they are paying them, regularly, whether it's weekly or biweekly, I mean that can certainly be a factor. Yeah, in that as well. And again, having a couple of these does not 100% guarantee one designation over the other, but these are the factors that, a fact finder would look into and, say, okay, this is trending towards, one designation over the other. Whereas, I can tell you with independent contractors, a lot of times they have flexibility of, where they can work and, when they get the work done. A lot of times they're paid on a project by project basis. And, a lot of times they use their own tools or, whatever, depending on the industry that they're working in, they'll use their own car or their own work tools or their own, laptops, computers, whatever the case might be. And, those factors would swing the other way and, kind of lead towards, potentially a 1099, excuse me, classification. So it really just depends. And like I said, I have people ask me this all the time, and I wish there was a hard and fast answer where I can kind of look at your universe of facts and say, 100% you're going to be a W-2 or 100% you're going to be a 1099. But a lot of times, a lot of these factors blend together, and you kind of make a educated judgment call, which usually ends up going
Yeah.
in the direction that you think. But it's kind of a semi gray area in the law.
Yeah, with trucking, it's interesting because yeah, on one hand, yes, it's a truck driver and you're a trucking company, so they directly related to the nature of the business you're doing.
Hmm.
On the other hand, if it's an owner operator, he owns this vehicle, so or she, and that's a big factor for them being classified as independent contractor. In terms of just administrative things, though, there are probably certain things that would be not a red flag necessarily, but would never like fly in an independent contractor agreement. Uh,
Hmm.
like they have to show up 8 to 5 with a 1 hour lunch break here, right? Something like
Yes.
that.
Exactly. The more control that the employer has over the worker, and I'm referring to them as a worker because I don't want to say employee versus
Right.
contractor, um, that trends towards, an employee designation. So if, we're saying, hey, you got to be here 40 hours a week, 9 to 5, and you're going to sit at your desk and use the company computers on the company systems and working for the company clients, and we're going to pay you biweekly or weekly, whatever the case might be. And, all of these kind of factors falling in line, I would argue, and I feel most would argue as well, that this would trend towards a employee relationship, given the fact that again, the level of control that's exerted by the employee over the worker, with the hours, the pay structure, and the ongoing kind of general work. Now, if you had somebody on the other end and said, hey, I have this kind of one-off project, I expect that it's going to take 2 to 3 months, and there might be ones that follow. You can work from home. I don't care what time you get it done, work all hours of the day if you want. But as long as it's done by this date, it's good. You can use your own computer and, take it from there. That I think there's a strong argument to be made, given other factors that we don't know, but based on those facts, very likely could be a 1099. So it really just depends.
Yeah.
And then, like I said, in a lot of situations, there's, factors going both ways, right? So you kind of have to make a judgment call and, take things from there.
Mhm.
But I think in tracking company, like the description of the work, because drivers have to be on time. Drivers use company's vehicle. Drivers have schedules, so they can't just use their own hours. So I think a lot of companies are abusing this 1099 rule. And what's interesting, drivers want to do the same because they get more taxes, like in terms of the return. But I'm just going to ask, maybe you can answer this.
Yeah.
Because I know there's a lot of lawsuits going on when drivers suing companies for a wrong type of employment. Like they're
hmm
not supposed to be on like 1099. And a lot of cases in California. And this cannot be action lawsuit all over United States if there are separate cases in the United States like this.
Yeah, I mean, I think that that's a big concern, the misclassification issue. And it's something that could certainly come into play here in Illinois. So, what would generally happen is if somebody files a lawsuit, whether it's for misclassification or not, it could be something totally unrelated. It could very well open up a can of worms for the employer in the sense that the Illinois Division of Employment Security, IDES is what it's called, would now kind of have access to look into this. You could have IRS issues. And basically, anytime somebody is now going to look into this problem, again, it would open up several issues, and the company could be liable for certain back taxes and fines, and now have to reclassify all their employees. Now, I mean, there could be concerns with the individual who's bringing the claim as well, if they were maybe not up to par on their taxes. That's another thing to maybe consider in this. And without knowing all the facts, I mean, it's kind of hard to see how it would play out. But the point is whether somebody is suing the employer for misclassification itself or suing it for something totally unrelated. Once discovery starts and you're getting the documents and some of the financials have been opened up of the company, if that's relevant in the case, and somebody looks at this, they're going to say, oh, wow, I mean, this is a total misclassification, and it could lead to issues with the IDES in Illinois, as well as potentially at the federal level from the IRS, in which case you'd owe, the employer would owe, all back taxes, fines, have to, reclassify their workers, and it would just open up a big headache.
When you're putting together a new, say, contract, right?
Mhm.
Or looking at an existing draft that somebody brought to you from what they had before, what are some of the most critical things that you look for? Or, if you're creating a new one, what is like 5 things that for sure need to be in every employment agreement or contract or
First off, you want to review the whole thing from start to finish and make sure that every provision in there is totally clear, that there's no ambiguities, because if there's any room for debate or interpretation, that's a major red flag off the bat for me, because, everybody enters contracts and business relationships with the goal that this is going to work out great and it's going to be profitable for everybody. But the sad reality is, I wouldn't say oftentimes, but there are cases where the relationship goes south and people need to rework the agreement or, get out and part ways. And, you have to understand how that's done. So from a starting point, make sure that everything is totally clear. Secondly, I also look at the termination provisions in particular, because a lot of times those aren't drafted what I would consider up to par. And, like I said, everyone enters these agreements with the expectation that they're going to be in this relationship till the end of time. But oftentimes people change, relationships change, industries change, and you have to figure out how you would get out of the contract. So I want to know that for my clients. I mean, are we paying any sort of fee to get out? Is there certain notice requirements to get out? What exactly would we have to do? And if that is not clear, I mean, obviously we need to rework it or renegotiate it. And then I generally make sure that the contracts, if my client's signing it, that the other side drafted, that everything is two-sided, right? I mean, obviously when I draft my contracts on behalf of my clients, I'll usually make it as favorable as possible within reason for my client. And if the other side wants to push back, that's, something that we can negotiate. But when I'm reviewing it for a contract that somebody else drafted for my client to sign, I want to make sure that everything is even-keeled and fair. So we look at the indemnification provisions, which is what happens if, there's a lawsuit involved. We want to make sure that the other side's going to indemnify us for any, gross misconduct or negligence caused by the other party. We look at the timing, we look at the payment terms, and, the termination is the big one as well. So you kind of get into all of it. And I wouldn't say that, one or two provisions are more important than the other. I think the whole document is something that needs to be reviewed line by line from A to Z. And, we make sure to do that when, we're taking one in that we're reviewing and when we're obviously drafting one from scratch. So.
Mhm. One thing that we see often in legal documents is reasonable, right?
Mhm.
And it's mentioned a lot in business communications.
Yeah.
When it comes to say, a lawsuit or any kind of arbitration procedures, like who decides what was reasonable or not? Is that the judge or is that the experts or?
Yeah, so I mean that's what we would call legalese. It's something that people come to me all the time and ask, "Well, Rob, why do we have this in here? What is reasonable?" And it's it's something that you would put in there, and again, it's to make sure that the either party's actions just don't go so far out of bounds that it's something that would be deemed, for lack of a better term, not reasonable. And that would be determined, again, if a contract were ever put before a judge or an arbiter or, some other fact finder, they would review it, and it could be an expert as well if, it's a big trial and there's expert witnesses, but they would kind of deem what is reasonable in this case based on the facts and circumstances. And again, you put that in there because you just want to make sure that somebody isn't acting so out there so as to be doing something, totally wrong. And, everyone has to act in a reasonable way. It's a question that I get regularly, and it's just more of kind of like a legalese term.
Is there a difference between states? Like, I know there are some states that are more in favor over companies or corporations, and then
Mhm.
there are states that favor employees more.
Mhm. Yeah, I mean, there are certain states that are, traditionally known as, company favorable states, such as, Delaware and Wyoming. And then there's other states that, trend more for employees, like Illinois, for example. They, um, in the last 5, 10 years, they make it pretty difficult to enforce non-competes and, non-solicits unless certain kind of requirements are met. So some could argue that they're more employee/worker favorable. But there's not, nothing jumps off the top of my head that's like, so one-sided that like, oh, you'd want to, restructure and do all of your business there or anything like that. But, just you have to know and keep up on the law that like, things shift, industry shift, the law shifts, certain courts in certain jurisdictions just tend to lean slightly or, maybe not so slightly in favor of workers slash, companies. And, it depends, but it's not anything so jarring that you would, want to go, move and set up shop or anything like that.
Obviously a lot of clauses, a lot of different sections usually go into contracts, and two of the things that come up very often is non-compete and non-solicitation. Can you
Mhm.
just explain for in layman terms what is the difference and what are some of the things that may not be appropriate to include into certain types of contract?
Yeah, absolutely. So non-competes are generally provisions that say that any, employee or worker that you have when they leave the company cannot, or even while they're working for the company, cannot now go, start their own venture that directly competes with your business, and that obviously uses your confidential information, your proprietary processes, and whatnot. And a non-solicitation is similar along the same lines, saying that after an employee leaves, they cannot now go solicit certain of your clients, or in some cases even your workers, to come work for them, or work for a third party that they're now working for. If they go work for a competitor, they can't solicit clients and say, hey, come work over at company B where I'm at now. So they, again, there's certain factors that need to go in order for them to be enforceable in Illinois. You need to make a certain amount of money, and you need to have been, at the company for a certain amount of time, and it needs to have been reviewed by a lawyer and whatnot. So again, the law is kind of trending in favor of the worker to make it a little bit more difficult to have those be enforceable. But where they are relevant, I mean, I always recommend them in the contracts for my clients when we can put them in and when they would likely be enforced, should a situation like that arise. But it really depends on the situation. If it's a worker who isn't meeting a certain income threshold, automatically unenforceable. So it really depends on a case by case scenario.
Hmm. And yeah, something that comes up, like what are some of the things that, if agreement is properly put together, what are some of the things that your worker would be having a very hard time suing the company for? You gave me some good examples that
Mhm.
might be pretty dark, but things do happen. So
Yeah.
like, if something bad happened, what are some examples of, okay, yeah, it was bad, but it wasn't the company's fault, and you would be in a very difficult position if you try to sue a company for that.
Yeah, so I mean, in my contracts that I draft for my clients, we want to put really strong liability protections in there. So we want to make clear that in almost all circumstances, all reasonable circumstances, going back to that term, the worker or employee, or even a customer, vendor, or supplier, is going to have a really difficult time suing the company, so long as the company that I'm representing acts in good faith and is fulfilling their ends of the contract and fulfilling their obligations, and all of that. So what we put in there is, certain liability limiting protections, saying that unless we engage in, gross misconduct or negligence, gross negligence, you're really going to have a hard time. You're kind of disclaiming all liability in that sense. So again, to go back to what we were saying earlier, I mean, you just want to make sure the contract is drafted in an airtight manner, that everything is super clear. Both sides know their responsibilities, their obligations, their rights, the payment terms, the termination provisions, and then, these, limitation of liability provisions that I'm referring to now. We just make those super strong. And we say that, unless there's a circumstance of, gross misconduct or gross negligence by the company, you're essentially waiving the right to, come after us for, X, Y, and Z that might happen, either in the workplace or just in the extent of a business relationship, if it's with a customer or a vendor or supplier.
Mhm.
So we just draft it really strong. And, if the person who's signing wants to come back and, recommend some changes or negotiate a bit, that's fine. We're open to hearing that. But, oftentimes it just, you just sign it and it's not an issue.
So if two of the workers, say for example, had a personal disagreement at work, and
Hmm.
one like punched the other in the face and
Hmm.
broke their nose, uh, if you have your contract properly put together, they would have a very hard time going after a company for that.
Yeah, I'd say. And of course, there's always extenuating circumstances. I mean, if, we could create a whole fact pattern of maybe where the business would be on the hook in some, way, shape, or form. But based on what you're saying, no, I mean, as long as the contract is drafted in an airtight matter, the business had no, opportunity to stop the punch, or had no, duty to do that. Then yeah, I mean, I think that the person, I mean, anyone can bring a lawsuit, right? I mean, it can
Right.
be frivolous, it could have no merit or no basis, but I think that the person would have a, a really hard time bringing some sort of, actionable claim, that, actually has a chance of succeeding in a case like that.
And what are some of the protections that could be there against frivolous lawsuits? Like, so anybody would just, oh, I can just sue for whatever.
Yeah. So, I mean, what I always put into my contracts too is a fee shifting provision. So, a lot of times we'll put in that, if a lawsuit is brought between either party, the prevailing party, so the party who wins in any lawsuit, will get their attorney's fees reimbursed by the losing party. So what that generally does is it kind of acts as a deterrent to people filing frivolous lawsuits that have no, merit, basically, because you know that, hey, if I'm going to invest in hiring an attorney and doing all these, filing fees and court costs and waiting the 6, 9, 12 months for it to be heard by a judge, and at the end I'm just going to lose because I have no strong argument, I'm going to have to pay, all of their attorney's fees too. So I'm kind of on the hook for double, right? And I found that acts as a strong deterrent for people bringing frivolous claims. So that's,
Right.
that's one way. And then otherwise, not to, keep repeating myself, but just making sure that all of the other provisions in the contract are, really strong and airtight, because, I can tell you a lot of people mainly focus on like the payment section. They want to know, how much am I going to be paid, or how much am I paying for this product or service? And I'm like, that's all well and good, but let's also focus on the rest, because I think the rest of those provisions are just as important, because, you could pay or receive payment, but if the contract falls apart, then, that's a separate issue in and of itself.
And we are talking about lawsuits because that's what the first thing that comes to mind for a lot of people, myself included. But when we were working on our documents, there was another option that you did put in there, which, yeah, I've heard about, but I didn't know much about, which is arbitration. So
Yes.
can you talk a little bit about what arbitration is, how it's different from lawsuit, and what are some of the benefits
Yeah,
of
of course.
arbitration versus lawsuits?
So what I generally put in my documents now is kind of a multi-layered approach. So, if there's a dispute, which we hope that there never is, what I generally have the parties do, and we'll put a provision in there saying this, that for, either 15 or 30 days, whatever my client wants, we're going to put in that the parties agree to kind of meet offline, off the books between them. I mean, you can have your attorney present if you want, but a lot of times the parties will just kind of communicate amongst themselves and try and, let cooler heads prevail, so to speak. They'll meet, they'll discuss the issue, they'll try and reach a resolution, by themselves, which is a great way of doing things, because again, then you save on attorney's fees and before you escalate it to formal dispute resolution, right? So I would say, most of the time the parties are able to reach a resolution amongst themselves just by doing that, assuming they're able to take a step back and cool down a bit. If at the end of that time period, 15 or 30 days goes by and there's no resolution, the way that the world is trending, and most industries are trending, my clients will put in what's called an arbitration provision, saying that, hey, if the parties are unable to reach that first agreement after that meeting offline, instead of going to your traditional court channels, they're going to file a case in front of an arbitrator. And what that is let's say you file a case in Cook County or DuPage County through the traditional court dispute resolution process. You're hiring your attorneys, you're filing the case, you're incurring court costs. Sometimes you're waiting 6, 9, 12 months or beyond to get in front of a judge. You have to go through discovery. I mean, it's just a very long, drawn out, expensive, stressful process for all parties involved. If you go to arbitration, it's a lot quicker. It's generally a lot less expensive. I mean, yes, you do have attorneys representing you, but it's just in front of a neutral arbitrator. It's kind of a watered down version of kind of the pretrial arbitration, the pretrial processes with regards to discovery and things like that. So again, it's usually a lot more efficient. It's a lot less costly. You still get a binding decision, and it's a lot quicker. So instead of waiting that year, I mean, you can usually get in front of an arbitrator much quicker, and, you're just hearing it. You don't have to go through all of those channels of, the various hearings and then waiting a month and all of this. So, and when you get the decision, it's still binding. So you get the decision, you have it, certified by a court, and you're good to go. It's just as good as getting a judgment. So I would say, over the last handful of years, I've had them in all my contracts. Or at least 90% of them. And the way that the, world is trending and industries are trending, like, usually all my clients today want them in there. And then there's also a third that you could do that's not binding, but that's just mediation, and that's more informal too. So that's kind of like what I discussed in step one with the parties meeting on their own. But if you did ever want to go in front of a mediator, the parties would just meet. Again, third-party mediator, you sit down, you kind of talk out the issues, you try and reach a resolution, but that's not binding. So that's, people do it, but usually you would have it paired with, mediation and arbitration, or what I mentioned, the parties meeting offline and then arbitration as well. So like I said, I strongly recommend it for all my clients. I think it's a great dispute resolution tool, and it's, it's just more efficient and speedier than going through the proper channels, especially with the backlog in the courts and all of that. So highly recommend it.
And if it comes to arbitration, is that the point where you would try to hire litigation attorney, or would somebody like you would still be able to handle arbitration process?
I would go with a litigator because again, it's similar to the courtroom in the sense that you're interviewing witnesses and putting on a case. I'm actually a licensed arbitrator myself, so I will hear those cases. But as far as the attorney that you want representing you, I would go with a seasoned litigator, somebody who does courtroom work. Just because, like I said, there are a lot of nuances and a lot of similarities to traditional, courtroom, case trials and whatnot. So yeah, I certainly go with a litigator in that case.
In your experience, like what are the most like crucial contract mistakes that you see people make and that cost them a lot of money in the end? They can even lose the business. And I know we went over it.
Yeah.
Right. You mentioned a lot of interesting case scenarios, but like, have you seen something that is just brings a lot of attention?
Yeah, absolutely. And especially in today's day and age with the rise in popularity of AI, just to answer your question quickly, I would say it's ambiguities in any of the provisions of a contract can create issues. But what I have seen an uptick in the last, 2, 3 years is people coming to me, new clients, and they say, hey, Rob, I put together this contract on my own. I used AI or I purchased it from a third party website, however they went about getting it. And, I've been using it for, 3 months and it seemed to be working fine. But now I have this kind of large issue with a, client or a customer, or, in some cases it's a vendor. And, how do we kind of untangle this? And then I will review the agreement. And full disclosure, while sometimes they're, okay, it's a good start type thing, I would never recommend somebody to take an AI contract, at least not now until the processes get a lot better, and then just, carte blanche, use that with their clients. I mean, if anything, and I'm happy to provide this service to people, if you want to, try and save on legal costs a little bit and put something together with your AI and then have an attorney review it and beef it up and, close a lot of the gaps, then, that's one thing. But I strongly recommend people don't just take it and then start using it because there are just things that you don't see in there. Even if it does touch on like a lot of the provisions, that's all it's doing. It's touching on them, right? And it's not necessarily always customized fully to your business operations. And there's always blind spots. So like I said, I recommend people don't do it at all. But if they're going to do it, I recommend they put it together on their own like they want to, and then have, a legal professional, whether it's, me or somebody else, at least review it and, redline it, mark it up, beef it up a little bit for them because there are just so many blind spots. So I've had a lot of people coming to me with that type of stuff that, hey, I've been using this and it was working fine until it's not. And quite frankly, in order to fix those issues now, you're going to be spending a lot more money than it would have cost for you to just draft the initial contract and have it airtight to begin with. And not only are you going to have a financial impact, but you're going to be stressed out. It's going to cost a lot more time. And this is all energy you should be putting in your business to grow it, So that's one thing, especially with this rise in popularity of the AI, like, it's a great thing. I mean, it's a great resource, but, please, please, please don't use it solely for, your contracts.
Yeah, that was actually my question. I was going to ask you exactly that thing about AI and how that affects your work.
Yeah, people do all kind of like they do medical diagnosis right now.
Oh
Yeah.
yeah, yeah.
Yeah, and I mean
So,
there is great information on there. I'm not one of the attorneys that's going to tell you, "Hey, never use it. It's a horrible
mhm,
tool," because it's a great tool and it gets you a lot of valuable insight into certain things. But I don't think it's quite there yet where you can just, spit in some information about your business, give me a contract and then actually use it with your clients because if you do that, even if it's not in the first month or two, eventually you're going to run into a problem because, I've seen those things and there's just a lot of glaring holes in there, especially people without legal experience. They just skip right over it and, they don't understand until it becomes a major
right.
problem.
Yep.
And then at that point, it's going to cost you a lot more money. And, maybe more importantly, it's going to be really stressful for you. It's going to keep you up at night and take away your energy that you could be focused on growing your operation.
Good.
Are there tells? Like, have you looked at the contract and then asked, did you use AI to create this?
Yeah, I mean, not necessarily tells, but you can usually see that this is either AI drafted or just very, very poorly drafted because again, like when you read through it, I mean, certain sections should really be, dense. They should pack a little bit of punch. And a lot of times I'll see, telltale, the indemnification provision or the limitation of liability provisions that we were talking about. Maybe it's like, one or two lines. And, again, maybe you can do it in one or two lines, but it's certainly not addressing everything that the business, needs. And, that's just a major red flag for me. But recently, a lot of people just come straight up, tell me and say, hey, I put this together with AI and, it was working fine. And, now it's not. So how do we kind of correct this? So I think it's just becoming so popular that, people, there's no reason to try and hide it. And quite frankly, I'd like to know too, because, if that's what you're working with, it'll be helpful for me to understand, hey, how did this document get created and why does it look the way it looks?
Do people sometimes would like run your drafts through AI and come back to you with like notes that AI gave them based on your work?
I mean, if they do, they haven't necessarily told me about it, but I mean, maybe when we have, our comprehensive follow-up calls, what I do when I draft a contract is there'll be a lot of back and forth between me and the client. I gather all the business information. I will go through my drafting process, and then there'll be subsequent, I'll send the client drafts, you'll review, have some comments and insight, and then we'll circle up, discuss it. I'll make, revisions to your liking and, based on what's needed. And then we'll do that, a couple of times until we have, a final product. So, I mean, people are welcome to do that. I'm sure maybe people have, they've never told me if they did, but a lot of times from my clients, I'll get back insightful comments and, they're what they
Yeah.
want for their business. So maybe they did get it from AI. And if they did, then that's great because, then now they have kind of some more information. So
Yeah, that's just
I'm not opposed to
true.
it.
It's just a tool, right? Like,
Yeah.
yeah, just use it as a tool. Don't just rely on it for everything.
I have a business, and obviously the first step will be to come to you so you can review my contract, right? Or maybe you can create a contract for me.
Mhm.
As like on this initial stage of my business, right? Like I just starting. So what would you recommend doing? Like obviously I have to do the contract to protect myself, especially if I'm hiring employees,
Mhm.
and I have to put all kind of legal stuff in there, like non-disclosure and arbitration and all kind of components, right? So
Yeah.
what would be the first step? Like I'm opening my business and then I need a
Mhm.
contract, right? And what should be in this contract?
So the first step would be, you have this great idea, you're starting your own business. I would certainly, like we discussed earlier, form some sort of entity to get you liability protection. So I would, you can come to me, or you can also do it on your own, whatever you prefer. I would form an LLC through the state. You go to the Secretary of State, and you get your name and your formation documents and all of that, and get all of that in order. Secondly, would be to now take those formation documents and get what's called an EIN through the IRS, and it allows you to open up a business bank account, and then you can kind of be off to the races. If you have partners in your business, if it's just you, you can, kind of move on to the next step and start putting together your contracts. But if you do have partners, what I would strongly recommend is putting together what's called an operating agreement and having that on file for your business. And what that is basically lays out the ground rules for. It's an internal facing document, but it lays out the ground rules for your business between the partners, right? So, if one person has more equity than the other, it'll be stated there. If one person has contributed more money to the business, it'll be stated there. If you want to discuss distributions and how money is going to be distributed to the partners, it'll be addressed there. How taxes are handled is addressed there. And, again, the termination provisions are addressed there. If, there's ever a dispute between the partners, it's going to all be handled in the operating agreement. So, if it's just you, I still recommend you have one just to kind of have on file, just to have. But if you have two or more partners, I 100%, you really need that in there in order to get up and running and make sure that all of your ducks are in a row. So I'd handle that. And then the third step would be to, like you said, put together the outward facing contracts for your business, whether it's for, your clients, your customers, if you're working with vendors or suppliers. You handle those like, okay, I'm going to be, providing transportation on these routes, or I'm taking on X number of clients. You want to put in all of that, like we discussed, the payment terms, the limited liability protections, indemnification, termination, all of that that's going to set forth your relationship between you and the people that are hiring you to do the work. And then the small caveat to that is underneath, if you're taking on employees or contractors, like you were mentioning, you're going to need some sort of agreement between them. So if they're 1099s, you would put together what's called an independent contractor contractor agreement, which is kind of like a watered down employment agreement, but it just sets forth the ground rules between you and your workers, your contractors. Or if you have W-2 employees, you'd put together a formal employment agreement, which kind of lays out the groundwork between you and your employees. And once those are all set, I mean, you kind of can take off and grow at your leisure. But throughout the lifespan of your business, I mean, there's always likely going to be, contracts put in your face. Again, if you're working with certain third-party suppliers or vendors or things like that, they may ask you to sign certain things. And I always review those for my clients too. They'll, call me up and say, "Hey, Rob, I got this 50-page document. I don't want to sign it until somebody looks it over. Would you mind, reading it over?" And I'm always happy to do that. And, if it's warranted, we can go back and negotiate certain changes or make, requests for revisions, things like that, just to make sure that everybody's comfortable with the relationship. Yeah,
Yep.
and
Another question, let's say we talked about the ownership. Let's say if partnership, I'm sorry. So let's say I
Mhm.
have a partner and I don't have it anymore, like I'm just want to be on my own. Do you help with transfer of ownership as well? Let's say if
Yeah, absolutely. So what would happen in a case like that is, assuming it's an amicable, breakup of the partners, like, it would be a clean split. But, oftentimes one partner is buying out the other, and you would do, an equity transfer, or, in an LLC terms, it would be a membership interest transfer. And it really just depends on the situation. If it's amicable, it's very easy. There would likely be some sort of payment, and we update the documents accordingly. And now you would be the sole member of the LLC. It gets a little tricky if it's not an amicable, split between the partners, because then a lot of times you got to divvy up, hopefully litigation, it doesn't reach litigation, but a lot of times you got to divvy up the assets of the business, the money, the finances, figure out taxes. And if people aren't working together to reach a amicable resolution, we have to have hard fought negotiations to figure out who gets what. And assuming we're able to get that done, then we can reach an agreement and do the, kind of membership interest transfer. But if you're not able to reach an agreement, it's what's called a deadlock. If there's just two partners, oftentimes you'd have to go to a third party, whether you find yourself in court or an arbitrator or, something like that, to try and resolve this. But, the more amicable it can be, the easier.
All right, another question, because in my line of business, a lot of times trucking company are bought and sold. And
Mhm.
that's what my clients want to know. They usually ask, like, do you know someone who can, like, we're selling the company and we need to transfer all the ownership to another owner, to a new owner.
Yeah.
And I heard that it might be super problematic, especially if the transfer goes to a different state. Like, let's say if
Mhm.
I have a company in the state of Illinois, and then I want to sell it to the owner in the state of Ohio, but I'm not the owner anymore. Are there any complications with the transfer of ownership?
There certainly can be. And, even if they're not problems, there's certainly hiccups and challenges involved because, if you have, let's say, an Illinois entity and you're selling it to somebody in a different state and they want to run it from that state, I mean, there's just a lot of red tape that's going to have to go from transferring your Illinois LLC or entity, whether, if you have a corporation, and transferring it over to that state. And on top of that, with, trucking in your industry, there's some added compliance issues, right? Because you're dealing with drivers crossing state lines, you're dealing with vehicles that are registered in certain states. And there's just a whole bunch of regulations and kind of restrictions that go into that. So from a purely business standpoint, I mean, it can be done, but like you said, I think that there's, presents some challenges if, as opposed to if you're just selling, let's say a, fast casual restaurant from, an Illinois owner to another Illinois owner. There are some, special caveats in your industry, and those are all things that, it's really important to work with a good compliance partner and a good team. So, like I said, that's the other thing for my clients that are starting businesses. I really recommend that they put solid people around them, right? So you want a really good tax professional, a really good accountant, a really good lawyer from the business end things. And depending on your industry, like with you guys with trucking and a lot of my franchising clients with franchising too, I see a lot of parallels. There's a lot, very heavily regulated industries. You want like, a compliance expert in there. Again, whether that's your attorney or your tax guy or your accountant,
Or
or
you
somebody else. What's that?
or you're tracking consultants. Just
Yes,
kidding.
yes, exactly. So you want to make sure that you have, the proper people in place to guide you and, kind of take you from, point A to point B when you're going through these kind of deals and transactions.
Oh, great. Yes,
Uh,
that's a great advice.
Yeah.
So a lot of things change, right?
Mhm.
Especially the last couple of years. And at the state level, politics affect a lot of things, like depending on, like uh, election campaign for some district figure or another. And uh, how do you keep up with all the changes? How do you, because it's important in your work, where do you go to keep yourself educated?
Yeah, absolutely. A lot of reading. We'll get daily alerts on, certain court cases that are coming out in the state of Illinois and certain, arbitration decisions to the extent that they're public. A lot of them are private, but you just got to stay on top of it. A lot of articles reading, you stay involved with the legal journals and publications. And, that's part of our job as attorneys, to be up to date on the latest. And that's also what I recommend to my clients too, so I'll draft contracts and they'll put them to good use and be doing great with all of their documents. But then 3, 4, 5 years go by and, the law has changed, the world has evolved and certain industries change. And also my clients' businesses change, right? They grow, they, morph a little bit. And I always recommend that they, keep fresh with their documents. And, that's something that I can do or, they can do on their own, whatever they prefer. But I always recommend every few years to do like a little bit of a facelift and just to, not to do any major changes unless they're necessary based on your business, but to at least just refresh things on, the new norms for, the industry and the law and the world as it's trending. So like I said, there's one example is the arbitration stuff. A lot of people are doing that now. And, that's kind of become the status quo and the norm and something that's, I highly recommend. So there's things like that to just keep on top. It's just stuff for me to keep on top of and also stuff for the clients to keep on top of. And I think it's important for everybody to, just keep things refreshed every, you don't have to do it every 6 months or anything, but every few years just to kind of revisit and make sure that everything is up to date, both with the law and compliance and the regulations, but also with how the company itself operates. Because again, I work with a lot of clients that, start off as, small mom and pops that they're, very inception and then now have grown to, 50, 75 employees. And by nature of that, as they've grown, they've gotten, bigger clients and more employees and, things need to be updated accordingly. So I think that's really important, on both ends.
And how do you deal with the stigma of a lawyer being a liar and always just trying to get more money out of you? Do you encounter that perception in your business, and how do you try to navigate that?
Yeah, I mean, honestly, I think it's very cringeworthy. I certainly get the perception, and I pride myself on not being like that. I'm sure you can tell
I can
working
attest
together
to that.
over, yes, working together over the last handful of years. I try not to be, the standard attorney who's a stickler with his time and, always doing those types of things. And, I think, some people get a bad rap, but sometimes the perceptions are justified. It really depends on, who you're working with and who you're talking to. But that's why I think it's important to, work with good people that you mesh with and vibe with, for lack of a better term, because when you're drafting contracts or putting together, entity ownership documents, and, this is, while the attorney is going to be doing the heavy lifting and the drafting, like when we work together, there's a lot of, meetings and, Zoom and phone calls and whatnot. So you want to make sure that you get along with the person, they have a good, aura about them and that it's somebody that you can see yourself working in the trenches with for, an extended period of time. So
Are there any
Right.
red flags? Like if you're approaching an attorney and the attorney does or says this thing, then you would rather look for somebody else.
I mean, I think it's just kind of like a feeling you get when you speak to somebody. Like, everybody thinks of like, if an attorney's, just talking about fees up front or if they're really stingy with their time. A lot of people, if they're billing by the hour, they're, real sticklers with that. If you just get a bad feeling when you're working with them that this is kind of going to be a slog of a relationship, that's certainly somebody I would stay away from. But otherwise, I mean, if it seems too good to be true, it probably is. Like, if you go to a lawyer and they promise you the world and tell you, oh, it's going to be super easy, this is how we can do it. And, alarm bells might be, going off, especially if it's kind of a complex issue. So I think, one of the most important things you can do as an attorney is just be transparent. If it's something that's outside of your area of expertise or your wheelhouse, like always be upfront and say it, because why would you take on something that you're not familiar with? Likewise, if it's a particularly complex situation with, let's say a 50% chance of success, why would you promise the world and say, oh, this is going to be no problem, and then, just disappoint your client later? So, what's important for me and, the people that I work with is, full transparency. If something's out of your wheelhouse, just say it, and be honest with the chances of success. Like, hey, I think we could put together a really great document for you, a really great contract that's going to, suit what you need it to do. But here are the challenges because of, whether it's your ownership structure or the way that you've been operating. You have to be totally transparent and honest with your client, just like you expect your client to be transparent and honest with you. So, it's a two-way relationship, and that's a good thing about attorney-client privilege and stuff. Like, you can be open and honest with each other, and it should be a vault both ways. So I think that's very important.
All right, that was all the questions we had for today. I'm sure that's not going to be our last conversation, because that was very interesting. And if we get questions from our viewers, we can do an episode just answering those. For now, you will find Rob's information in the description of this episode. And I want to thank you, Rob, again for finding time to meet with us today. Thank you, Rob,
Thank
very
you, Rob.
much.
Thank you
Yep.
so much to you both for having me. I really appreciate it, and I'm happy to come back anytime.
Hey, thank you so much, Rob. It was
Nice.
very informative.